Hello and welcome to today's episode, which deals with legal aspects of export contract, including Incoterms. Students, let's start with learning the concepts and basic terminology for better understanding. Types of legal systems. The legal systems which operate in certain overseas market may have important implications for legal agreements and contracts and their enforceability. Three basic types of legal systems are in use globally. 1. Common law. 2. Civil law. 3. Theocratic law. Before we go into details of this and the entire topic, allow me to give you a quick introduction about myself. I am Ms. PALLAVI Mohan, working since 17 plus years, both nationally and internationally. Worked in 5 countries and studied in 3 countries. Have held leadership positions in the field of marketing, retail, operations, PR and communications. Recent assignment was with Samsung Electronic as corporate communication professional. Students, the 3 basic types of legal systems are 1. Common law. 2. Civil law. 3. Theocratic law. Common law, based on tradition, precedent and usage as practiced in Australia, UK, USA and many Commonwealth countries. Business contracts tend to be lengthy to accommodate possible contingencies and interpretations. However, there is flexibility which takes into account particular situations and circumstances. Civil law, based on a detailed set of written rules and laws which constitutes a legal code. It is practiced in Western Europe and throughout Asia and Africa. Because all laws are codified and concise, parties to contracts are concerned with explicit wordings. This system is less confrontational than common law. Theocratic law, based on religious teachings such as Islamic and Jewish. Businesses which operates in such countries must be extremely sensitive to local cultural values and beliefs, and all activities must comply with local laws and traditions. Whichever legal system is operating, you must be aware of the enforceability of agreements such as those relating to confidentiality and sales contracts. Enforcing a contract may be a very expensive option and may involve arbitrations. Whichever legal system is operating, you must be aware of the enforceability of agreements such as those relating to confidentiality and sales contracts. Enforcing a contract may be a very expensive option and may involve arbitration. Settling international disputes. The International Commission on Arbitration is responsible for the settlement of commercial disputes and the legal and procedural aspects of arbitration. Incoterms, the most commonly used rules for the interpretation of trading terms, are those set down by the International Chamber of Commerce and are known as Incoterms. They establish a clear rules which govern the responsibility of exporters and importers in relation to sales contracts. Incoterms cover all aspects of international delivery of goods, including transport, custom clearance, payment responsibilities, ownership of risk and condition of goods at various locations in the transit process. They do not deal with transfer of title. Incoterms were devised and published by the International Chamber of Commerce and endorsed by the United Nations Commission on International Trade Law. The most commonly used terms are ex works. The seller makes the goods available at his premises. Free alongside ship at a named port. Since 2000, sellers have been responsible for clearing goods for exports. Free on board FOB, one of the most commonly used terms. Sellers loads the goods on board in a designated vessel and the cost and risks are transferred at the ship's rail. Cost, insurance and freight. CIF, another common arrangement under which the seller pays all cost of freight and insurance up to the port of destination. Although originally used in sea transport, many of the 13 terms have been updated to cover other multimodal transport systems. Students, we will study the Incoterms in details and also study topics supporting the same. Incoterms. The Incoterms rules or international commercial terms are a series of predefined commercial terms published by the International Chamber of Commerce. They are widely used in international commercial transactions or procurement processes. A series of 3-letter trade terms related to common contractual sales practices. The Incoterms rules are intended primarily to clearly communicate the task, cost and risk associated with the transportation and delivery of goods. The Incoterms rules are accepted by government, legal authorities and practitioners worldwide for the interpretation of most commonly used terms in international trade. They are intended to reduce or remove altogether uncertainties arising from different interpretations of the rules in different countries. As such, they are regularly incorporated into sales contracts worldwide. First published in 1936, the Incoterms rules have been periodically updated with the 8th version, Incoterms 2010, having been published on January 1, 2011. Incoterms is a registered trademark of the ICC. Incoterms 2010. Incoterms 2010 is the 8th set of predefined international contract terms published by the International Chamber of Commerce, with the first set having been published in 1936. Incoterms 2010 defines 11 rules, down from the 13 rules defined by Incoterms 2000. 4 rules of the 2000 version: delivered at frontier DAF, delivered ex-ship DES, delivered ex-K DEQ, delivered duty unpaid DDU are replaced by 2 new rules: delivered at terminal DAT, delivered at place DAP in the 2010 rule. In the prior version, the rules were divided into 4 categories, but the 11 predefined terms of Incoterms 2010 are subdivided into 2 categories based only on the method of delivery. The larger group of 7 rules may be used regardless of the method of transport, with the smaller group of 4 being applicable only to sales that solely involve transportation by water, where the condition of the goods can be verified at the point of loading on board ship. They are therefore not to be used for containerized freight, other combined transport methods, or for transport by road, air or rail. In some jurisdictions, the duty cost of goods may be calculated differently. For example, in India, duty is calculated against the cost, insurance and freight (CIF) value of the goods, and in South Africa, the duty is calculated against the free on board (FOB) value of goods. Because of this, it is common for contracts for exports to these countries to use these Incoterms even when they are not suitable for the chosen mode of transport. If this is the case, then great care must be exercised to ensure that the points at which costs and risk pass are clarified with the customer. The seller makes the goods available at their premises or at another named place. This term places the maximum obligation on the buyer and minimum obligation on the seller. The ex-work term is often used when making an initial quotation for the sale of goods without any cost included. Ex-works means that a buyer incurs the risk for bringing the goods to their final destination. Either the seller does not load the goods on collecting vehicles and does not clear them for export, or if the seller does load the goods, he does so at buyer's risk and cost. If parties agree that the seller should be responsible for the loading of goods on departure and to bear the risk and all cost of such loading, this must be made clear by adding explicit wording to this effect in the contract of sale. There is no obligation for the seller to make a contract of carriage, but there is also no obligation of the buyer to arrange one either. The buyer may sell the goods onto their own customer for collection from original seller's warehouse. However, in common practice, the buyer arranges the collection of the freight from the designated location and is responsible for clearing the goods through customs. The buyer is also responsible for completing all the export documentation, although the seller does have an obligation to obtain information and documents at the buyer's request and costs. These documentary requirements may result in two principal issues. Firstly, the stipulation for a buyer to complete the export declaration can be an issue in certain jurisdictions where the customs regulations require the declarant to be either an individual or corporation resident within the jurisdiction. If the buyer is based outside of the customs jurisdiction, they will be unable to clear the goods for export, meaning that the goods may be declared in the name of the seller, in breach of the ex-works term. Second, most jurisdictions require companies to provide proof of export for tax purposes. In an ex-works shipment, the buyer is under no obligation to provide such proof to the seller, or indeed to even export the goods. In a customs jurisdiction such as European Union, this would leave the seller liable to a sales tax bill as if goods were sold to a domestic customer. It is therefore utmost importance that these matters are discussed with the buyer before the contract is agreed. It may well be under Incoterms such as FCA, sellers, premises may be more suitable, since this puts onus for declaring the goods for exports onto the seller, which provides for more control over the export process. The seller delivers the goods cleared for export at a named place, possibly including the seller's own premises. The goods can be delivered into a carrier nominated by the buyer or to another party nominated by the buyer. In many respects, this Incoterms has replaced FOB in modern usage, although the critical point at which the risk passes moves from loading abroad to the vessel named place. It should also be noted that the chosen place of delivery affects the obligation of loading and unloading the goods at the place. If delivery occurs at the seller's premises or at any other location that is under the seller's control, the seller is responsible for loading the goods onto the buyer's carrier. However, if delivery occurs at any other place, the seller is deemed to have delivered the goods once their transport has arrived at the named place. The buyer is responsible both for unloading the goods and loading them onto their own carrier. CPT, Carriage Paid To. CPT replaces the vulnerable CNF, cost and freight, and CFR terms for all shipping modes outside of non-containerized sea freight, the seller pays for the carriage of the goods up to the named place of destination. However, the goods are considered to be delivered when the goods have been handed over to the first or main carrier, so that the risk transfers to the buyer upon handing goods over to the carrier at the place of shipment in the country of exports. The seller is responsible for origin cost including export clearance and freight cost of carriage to named place of destination, either final destination such as buyer's facilities or a port of destination. This has to be agreed by the seller and buyer, however. If the buyer requires the seller to obtain insurance, the Incoterms CIP should be considered instead. What is CIP? CIP, carriage and insurance paid to. This term is largely similar to the above CPT term, with the exception that the seller is required to obtain insurance for the goods while in transit. CIP requires the seller to insure the goods for 110% of the contract value under at least the minimum cover of the Institute cargo. Clauses of the Institute of London underwrites, which would be Institute cargo clauses or any similar set of clauses. The policy should be the same currency at the contract and should allow the buyer, the seller and anyone else with an insurable interest to the goods to be able to make a claim. CIP can be used for all modes of transportation, where the Incoterms CIF should only be used for non-containerized sea freight. This Incoterm requires that the seller delivers the goods unloaded at the named terminal. The seller covers all cost of transport, export fee, carriage, unloading from main carrier at destination, port and destination port charges, and assumes all risks until arrival at the destination port or terminal. The terminal can be port, airport or inland freight interchange, but must be facility with capability to receive the shipment. If the seller is not able to organize unloading, they should consider shipping under DAP terms instead. All charges after unloading, for example import duty, taxes, customs and on carriage, are to be borne by buyer. However, it is important to note that any delay or demurrage charges at the terminal will generally be for the seller's account. DAP, delivered at place. Incoterms 2010 defines DAP as delivered at place. The seller delivers when the goods are placed at the disposal of the buyer on arriving means of transport, ready for unloading at the named place of destination. Under DAP terms, the risk passes from the seller to the buyer from the point of destination mentioned in the contract of delivery. Once goods are ready for shipment, the necessary packing is carried out by the seller at his own cost, so that goods reach their final destination safely. All necessary legal formalities in the exporting country are completed by the seller at his own risk and cost to clear the goods for export. After arrival of the goods in the country of destination, the custom clearance in the importing country needs to be completed by the buyer at his own cost and risk, including all custom duties and taxes. However, as with delivered at terminal DAT term, any delay or demurrage charges are to be borne by the seller. Under DAP terms, all carriage expenses with any terminal expense are paid by seller up to the agreed destination point. The necessary unloading cost at final destination has to be borne by buyer under DAP term. Seller is responsible for delivering the goods to the named place in the country of the buyer and pays all cost in bringing the goods to the destination, including import duties and taxes. The seller is not responsible for unloading. This term is often used in place of the non-Incoterms, free in stored, FIS. This term places the maximum obligation on the seller and minimum obligation on the buyer. No risk or responsibility is transferred to the buyer until delivery of the goods at the named place of destination. The most important consideration for DDP term is that the seller is responsible for clearing the goods through customs in the buyer's country, including both paying the duties and taxes and obtaining the necessary authorizations and registrations from the authorities in that country. Unless the rules and regulations in the buyer's country are very well understood, delivered duty paid DDP terms can be very big risk both in terms of delays and in unforeseen extra cost and should be used with caution. To determine if a location qualifies for these 4 rules, one needs to refer to United Nations Code for Trade and Transport Locations. The 4 rules defined by Incoterms 2010 for international trade where transportation is entirely conducted by water are below. It is important to note that these terms are generally not suitable for shipments in shipping containers. The point at which risk and responsibility for the goods passes is when goods are loaded on board the ship, and if goods are sealed into shipping container, it is impossible to verify the conditions of the goods at this point. Also of note is that the point at which risk passes under these terms has shifted from previous editions of Incoterms where the risk passed at the ship's rail. The seller delivers when the goods are placed alongside the buyer's vessel at the named port of shipment. This means that the buyer has to bear all costs and risks. The FAS terms requires the seller to clear the goods for export, which is reversal from previous Incoterms versions that required the buyer to arrange for export clearance. However, if the parties wish the buyer to clear the goods for export, this should be made clear by adding explicit wording to this effect in the contract of sale. This term should be used only for non-containerized sea freight and inland waterway transport. FOB, free on board. Under free on board term, the seller bears all costs and risks up to the point the goods are loaded on board the vessel. The seller must also arrange for export clearance. The buyer pays cost of marine freight, transportation, bill of lading, fees, insurance, unloading and transportation cost from the arrival port to destination. Since Incoterms 1980 introduced the FCA Incoterms, FOB should only be used for non-containerized sea freight and inland waterway transport. However, FOB is still used for all modes of transport despite the contractual risk that this can introduce. CFR, cost and freight. The seller pays for the carriage of the goods up to the named port of destination. Risk transfers to buyer when the goods have been loaded on board the ship in the country of export. The shipper is responsible for origin cost including export clearance and freight cost for carriage to named port. The shipper is not responsible for delivery to the final destination from the port, generally the buyer's facilities, or for buying insurance. If the buyer does require the seller to obtain insurance, the Incoterms CIF should be considered. CFR should only be used for non-containerized sea freight and inland waterway transport. For all other modes of transport, it should be replaced with CPT. This term is broadly similar to the above CFR term, in the exception that the seller is required to obtain insurance for the goods while in transit to the named port of destination. CIF requires the seller to insure the goods for 110% of the value under at least the minimum cover of the Institute cargo clauses of the Institute of London underwriters, which would be Institute cargo clauses or any similar set of clauses. The policy should be in the same currency as the contract. CIF can be used by any transport by sea and air not limited to containerized or non-containerized cargo and includes all charges up to the port terminal of entrance. CIP covers additional charges at the port terminal of entrance. Allocation of cost to the buyer-seller according to Incoterms 2010, seller buyer and seller buyer are indicated with 3 different colors: green, pink and yellow. This will help you to understand allocation of cost to buyer and seller according to Incoterms 2010, which we learned today. Students, now previous terms from Incoterms 2000 eliminated from Incoterms 2010. While these terms do not feature in the current version of Incoterms, it is possible that they may see in sales order contracts. Care must be taken to ensure that both parties agree on their obligations in this case. This term can be used when the goods are transported by rail and road. The seller pays for transportation to the named place of delivery at the frontier. The buyer arranges for custom clearance and pays for transportation from the frontier to his factory. The passing of the risk occurs at the frontier. DES. Where goods are delivered ex-ship, the passing of risk does not occur until the ship has arrived at the named port of destination and the goods made available for unloading to the buyer. The seller pays the same freight and insurance cost as he would under a CIF arrangement. Unlike CFR and CIF terms, the seller has agreed to bear not just cost but also risk and title up to the arrival of the vessel at the named port. Cost for unloading the goods and any duty, taxes, etc. are for the buyer. A commonly used term in shipping bulk commodities such as coal, grain, dry chemicals, and where sellers either owns or has charactered their own vessel. This is similar to DES, but the passing of risk does not occur until the goods have been unloaded at the port of discharge. These terms mean that the seller delivers the goods to the buyer to named place of destination in the contract of sale. A transaction in international trade where the seller is responsible for making a safe delivery of goods to a named destination, paying all transportation expenses but not the duty. The seller bears the risk and cost associated with supplying the goods to the delivery location where the buyer becomes responsible for paying the duty and other custom clearance expenses. With this, we have covered legal aspects of export contract including Incoterms. This is all for today. Hope you have understood. We'll see you again with the next topic. Till then, take care. Bye.